I'm pleased to introduce to you this morning our speaker, Mr. Wittlin, a 30-year experienced real estate business bankruptcy attorney whose office is here in Irvine. He helps sellers or buyers of properties resolve sales disputes in arbitration or court, and even brokers concerning the right to commission. He is also a 25-year editor of the Real Estate Law Update, a monthly publication which he writes for more than 300 attorney members of the real estate section of the Orange County Bar Association, for which he has received this section Most Outstanding Achievement Award. He is also an attorney on the call-in hotline for agents and has been a regular speaker at REIA here at least twice a year. Today, he is here to speak with us on the most important thing as real estate agents need to know about is protecting the real estate broker's right to a commission in a bankruptcy sale. So please, let's welcome our speaker, Attorney Pete Wittlin.
Thank you for the intro, Connie. I wrote it myself. Okay, short sales is no equity in the property. We're going to talk about where there's equity in the property but the debtor is in bankruptcy. The bankruptcy court will permit a sale of the property if there's equity in it, and you can get paid. I'm going to tell you how to do it. Okay. Everybody have a handout and the one-page addendum? No. Are there any extras? Connie? Yes, some people. All right, everything you want to know is in the handout. You can underline it, maybe make some notes to it, but it's all here. I'm going to start now. There are 3 different chapters for filing a bankruptcy case. One's called liquidation, that's chapter 7, we've all heard of that. 13 is called individual debt readjustment. That's a repayment plan for individuals. And then you've heard of chapter 11, that's like for airlines, for corporations and some larger individuals, as far as debt's concerned, who can qualify for chapter 13 treatment. That's also repayment plan. 13 is then chapter 11, say to the bankruptcy court, okay, I got a lot of debt that I owe. I'm going to start making my regular payments, and on top of that, over time, I'm going to cure the arrears. That's a 13 or an 11. That's bankruptcy law. And you can cure the arrears on a percentage on the dollar under certain circumstances. Doesn't have to be in full. Right. A point to note, chapter 11s are for the individual only and has no more than $336,900 in unsecured debt. It's liquidated, essentially not contested, and no more than $1,010,650 in secured debt. The court will determine the amount of secured debt on the home as no more than the fair market value. So if the debt on the home is over the fair market value, they'll knock it down for jurisdictional purposes. So that number is a little bit weak, so to speak. You can massage that. Most people have a home and they've got the mortgage. In many cases, it's over the amount. Okay, chapter 11 is for corps, limited liability companies, and for individuals who exceed 13 limits. In a bankruptcy sale of any realty, the bankruptcy court, and they're located in LA, Orange County, or Riverside, close to this area, wants to protect the interest of unsecured creditors to share in available sale proceeds, and has established certain procedural safeguards to achieve this. These are hoops through which the broker must jump through in order to be paid a sales commission. Failure to jump through these hoops may result in a sale with no commission paid. That's a bad result for the broker. We want to avoid that. Today I'll tell you about the hoops and how to pass through them so your sales efforts in bankruptcy will be profitable to you. Okay, at the bottom of page 1 we have rule number 1. It's called the pre-approval rule. In order to receive a commission on a bankruptcy sale of realty, the sale with certain exceptions needs to be pre-approved by the bankruptcy court. This requires a noticed application or motion, and is filed by the Chapter 7 or Chapter 13 trustee, sometimes by the debtor himself with the consent of the Chapter 7 or trustee, or in a Chapter 11 case, there's no trustee, just a debtor in possession, and he files it himself, he or she or the company. As I said, the debtor can file his own motion, either of the chapters, with the trustee's consent in 7 and 13. Now, the motion has to ask for three things: approval of the commission agreement, approval of the broker to procure the sale, his or her credentials, and the terms of the sale have to be approved. The motion may be one simply noticing intent to sell the property, and otherwise approving the broker and the proposed commission without a court order, without a noticed hearing. If no objections are filed, the court will enter an order. Or the motion can set a hearing date itself. So you see them both ways. The motion tells the court what the desired result will be and is supported by an attached sworn declaration signed by the broker about the proposed sale, the commission amount, and his or her competence to effect the sale. You have to make a good application, a good showing that you're able to do this, you're experienced. The sale generally requires a 10% down payment, an appraisal, and loan qualification by the buyer. It's not all cash. Hypothetical 1. Broker Barney obtains a listing from Ollie owner to sell Ollie's home for $500,000. Before an offer is accepted, Ollie files Chapter 7. While in the Chapter 7 case, Betty buyer submits an offer on listed terms to broker Barney. Your broker Barney. What should Barney do? Well, we have alternatives. Choose the best answer. Well, Barney should show Ollie, his client, the offer for his consideration. That's A. Or he should present the offer to Ollie's attorney, bankruptcy attorney, for evaluation. Or he should not permit Ollie to accept the offer other than subject to bankruptcy court approval, and have Ollie's attorney file a motion in bankruptcy